Baroness Lickleton.
Hello. Well, once again, in a way, my question relates to culture establishments. But once again, it is in relation to the stopping of regular and routine searches. Your reply to Carlile's question sort of implied that there was a sort of bureaucratic procedure that has to be gone through, which seems rather remarkably lengthy sometimes, but that just probably tells us more about norms than anything else. But given that until really recently, it's routine, and I know about the work of the YJB in investigating the use of routine searches, that routine searches have been the order of the day and part of the culture. I was hoping to hear, but didn't hear from you, was that this would imply that there would be probably some need for a review of the way the staff work. If they've been routinely used to the use of searches, they've got to adapt to perhaps a new way of going about their business and of dealing with the children and young people. And I wondered whether, as part of the process, not necessarily just of stopping searches, as has been agreed must happen, that there is some work done also routinely with the staff to adapt to and to accept such a change as would be part of the culture from now on, because presumably the staff have been doing these searches routinely without a problem, and it requires a different attitude, I would have thought, or maybe I'm wrong.
Cultural change.
Well, it's a cultural shift. I mean, yes.
I'm sure you're right. Although I think it would be absolutely wrong to leave you the impression that our staff are in one place on this issue. Actually, across the sector, I know that there are many staff who have much more radical views about how children in custody should be differently cared for than they are at the moment. So it wouldn't be the case that every single officer in a YOI, which is really what we're talking about at the moment, or an anonymous YOI, is of the view that they really want to retain the ability to carry out full searches, either because they want to make sure that the issue of contraband, which is what full searches is in policy terms really about, because they want to make sure that is kept as a minimal problem in YOIs, or for for a small minority, it is always possible that there are other motivations around the issue of full searching. It wouldn't be the case that all of our staff are there; that they just aren't, and many are already would be only to content to implement a change in policy. But you're absolutely right. Now, I suppose I was trying to say that, and I clearly didn't get it across as well as I ought to. These changes are not simply a question of, as you put it, a bureaucratic committee reaching a decision and saying it shall be so, and so it is. In any change, and this is quite a significant change, not just from the point of view of the young person, but also from the regime within a YOI. Any change needs a programme of cultural change, and that really is one of the main things that we're talking to NOMS about.
Sorry, I would just add to that I think certainly most senior, if not all senior managers within NOMS would be very welcoming of the decision to move to a risk-based approach. I think most of us felt frustrated on the basis of the security requirements. They are driven by what's called National Security Framework, which dictates that routine searches should take place. And I think many have argued for a long period now that those restrictions should be lessened, particularly for the children's state. So I think that we welcomed. I don't see much in terms of senior resistance within YOIs, and what I would say to supplement or really push through the issues around how these changes will be managed is that we are developing a new risk-based approach to monitoring within YOIs within the Youth Justice Board, and we are putting a dedicated module together which will monitor the progress against these changes. So we will have great visibility in terms of what will happen in terms of moving to new systems over the course of the next period.
Thank you. Well, we're over the allotted time, but can I just ask you one question that I think we should deal with? The Howard League has been arguing that the touch and hold policy is unlawful and circumvents the rules on the use of restraint. Do you have plans to ensure that the policy of touch and hold is withdrawn?
We are actively engaged in discussions with G4S about precisely what they're trying to achieve here, which is something that sits below and before restraint, as another way of exercising influence over children's behaviour, but needs obviously to fit within the legal framework. Having active discussions with them about the definitional thresholds, the mechanisms, the implications of the law, both the common law and obviously the statutory law in relation to that. We have no plan today to ask G4S to withdraw the approach. We have every plan to ask and work with them around refining it, and indeed there was a meeting last week in the YJB which lasted for more than 4 hours and involved us, amongst other things, using evidence from CCTV to explore the proper parameters. We welcome what they're trying to do, and G4S has got a very, very good track record in terms of reducing the amount of restraint within the 3 STCs for which they're responsible. And that's not only exemplified in terms of the total number of restraints really rapidly falling away, but also in relation to the issue of using any form of pain and destruction, which we're now down into single figures. It's reflected as well in terms of the statistics on injuries to children. The child hasn't been needed to be taken from an STC to a hospital for, I think it's the case, more than 2 years. So the track record is good, what they're trying to achieve is good. It's a very complex area of law, but more importantly perhaps than even that, it's a very complex area of behaviour and behaviours to think through, and we're very actively involved with them in that.
Right, well, I merely expressed from the chair that